Hi, I'm Caroline Wilson from Molyneux Associates, and with me is James Peterson, partner of GA Solicitors. I work with James a lot with regards to my clients and the shareholders and the corporate protection. James is here with me this morning to talk about the legal side regarding insurance, cross-option agreements, shareholders agreements, and we work together. So good morning, James.
Good morning, Caroline.
So James, obviously I recommend to all my clients that they get legal advice with regards to a shareholders agreement and cross-option agreement. Why is it so important for them to have that alongside the insurance?
So a shareholders agreement at the outset, when you first start up in business, is often something that people overlook and think, well, I'll get round to that, I'll do that another day. Unfortunately, we see time and time again, people don't get round to that, doing it another day. And the consequence of that can be quite tragic. Not only do the parties fall out on a personal level, they fall out on a business level, and ultimately it costs them a lot of money. The purpose really of a shareholders agreement is that when everybody's on the same page, everybody's got the same aims and beliefs, they don't anticipate any disputes, they all know what they want out of the business, and they put it in a shareholders agreement, and it avoids or mitigates any risks in the future. And quite often a shareholders agreement will prevent any dispute ever happening in the future between those parties.
Great. And from the cross-option side, what's the difference between a cross-option and a shareholders agreement?
So the cross-option agreement is something that I would recommend normally in conjunction with a shareholders agreement. The shareholders agreement covers all sorts of areas. It can be key decisions that need unanimous consent of all the shareholders to be made. It could be who can be a director. It could be how you're going to extract money out of the business. In relation to the cross-option agreement, it's specifically to do with if a shareholder tragically passes away or if they've got a critical illness, then it's what happens in those scenarios. The purpose of a cross-option agreement in those scenarios is the estate of the deceased will get a nice, good piece of money so that they can go forward with their lives. The continuing shareholders keep control of the business because ultimately the shares of the deceased are passed across to the continuing shareholders, and the continuing shareholders pay for those shares from the proceeds of an insurance policy which is being taken out in trust for them, and that money then goes to the deceased estate so that the relatives and the next of kin of the deceased are well looked after as well.
Okay, so James, tell me, how complicated is it to put this into place? Is it complicated?
It's not complicated at all for a shareholders agreement and cross-option agreement. They can be as simple or as complicated as the parties really want. At the end of the day, a shareholders agreement is just a contract, so there would always be key areas that we would recommend every business and all shareholders to cover off, but some of them want to go into more detail than that. A cross-option agreement in many ways looks very complicated because it has to be done in quite a technical way to get the tax benefits that we're trying to get from it, but the actual core principles of it are relatively straightforward, and as long as you've got a good corporate commercial solicitor guiding you, it's really easy.
Amazing, okay. So what are the repercussions if you weren't to have these in place as a business and personally, obviously?
Yeah, so just touching on the shareholders agreement, it's important. It normally makes the business decisions and makes the business run smoothly. Everybody knows where they stand from the outset. And then the critical thing really is around the share transfers, particularly with the cross-option agreement. If you don't have a shareholders agreement, you don't have cross-option agreements in place. For example, if somebody wants to transfer their shares, generally the position will be they'll be free to do that. So the other shareholders could suddenly find themselves in business with somebody they don't want to be in business with, and most shareholders don't want that to happen.
And how often do you see it from a solicitor's point of view where the people haven't had it?
Unfortunately, too common for my liking. Quite regularly we get business owners that come to us, say we started up this business 2, 3, 4 years ago, fantastic business. We started really small, we're now a fantastic business, making lots of money. Unfortunately, one of them's either they've fallen out with each other, or one of them wants to retire, or one of them wants to go to Australia, or one of them's got a different idea for the business. And that's where the problems start, because they go back and go, oh no, we didn't get shareholders agreement in place because at the time we had more important things to do. Fully understandable. The important thing is that you do get that shareholders agreement in place before the business is worth any money and before there's things to start arguing about.
So James, what comes first, insurance or the cross-option?
Generally speaking, when I'm speaking to my clients, I say to them, first and foremost, go and speak to your accountant or your financial advisors, people like yourselves. Do a bit of investigation, make sure they can actually get insurance in the first instance. There's no point in spending money on a solicitor and getting great agreements drawn up in place if you haven't actually got the ability to get the life insurances to go with it. Once you've done that and you're comfortable you're going to be able to get those insurances in place, then it's important to get proper advice to get a properly well drawn up cross-option agreement in place. Once a solicitor such as myself has done that for the client, we will then liaise with people like yourselves, as you know, so that you can make sure you get the proper insurance in place, that they're going to the right trusts for the benefit of the surviving shareholders. And then most important thing probably, or the thing that most business owners forget about, is that they've got to continually review that. So whenever the business changes in terms of value, or periodically, say annually, it's important to keep reviewing those policies, because ultimately the deceased estate is only going to get the proceeds of that life insurance policy. So if you've taken out a life insurance policy and the shares are worth £1 million, but then 10 years later the business is worth £10 million and those shares are worth half of that, say £5 million, you're only going to get the proceeds of that insurance policy going to the estate.
Thank you for coming today, James. It's been a pleasure.
You're more than welcome. I just hope it's been useful for people.